Joe Bartulis, who's an attorney at Fletcher Tilton, chair of the Labor and Employment Law Practice Group. Welcome.
Thank you for having me, Tim.
I should say welcome back.
Yes, thank you very much.
You know, when you were last here, we were when you were last here, we were talking a little bit about some of the laws and the impact that the ballot question, as it relates to marijuana, on the employer and the workplace. But we got a whole bunch of other issues we're going to cover this in the next couple segments.
Thank you. Thank you.
So maybe, you know, as we get into these issues, you have a very kind of specific and kind of important role at Fletcher Tilton as chair of the Labor Law and Employment Law Practice Group.
That's right. That's right. And I try to keep abreast of all the latest developments in these areas of laws, and I try to convey those to folks through articles and seminars that we conduct, and by kind folks like yourself having me on to talk about these things.
You know, and that's really important, you know, for our members. You know, they're very focused on their core mission, you know, whether it's taking care of patients, whether it be manufacturing the widgets, whether it's being the IT company that services other employers, retail. They're focused on the core mission. And this is a rapidly changing world. You know, there are changes that take place at the federal or state level on an annual basis that impact businesses and employers in terms of compliance and how they need to be treating people. So it's important that they stay current.
Oh, absolutely it is. And you mentioned their core business. So when folks are busy trying to run their businesses, while employees are a key integral part of that success of the business, oftentimes focusing on the employment laws or the regulations or all the obligations that an employer has to its employees, sometimes people don't keep up with those things as much as they may, because again, they're focused on the core aspect of their business, whatever that may be.
And so, you know, that's where, as an attorney, you can come in, not just when there's a problem or an issue, but to proactively kind of guide or update businesses on how they can stay ahead of these things or prepare for them.
Absolutely. I very much pride myself, as does my firm, on, you know, we find that proactive approaches are better than reactive approaches, obviously. And so if we can advise folks on what they need to do to be compliant with these laws in advance, not only are they compliant with the laws, but they can stave off a lot of potential litigations and the penalties and citations that may come from those things, which again take them away from their core business by having to focus on those things.
Right, right. So let's jump right in. In July of this year, the Pregnant Workers Fairness Act was passed.
Correct.
And there's some obligations in terms of, and I think most employers want to try and do the right thing by a pregnant employee. Maybe you can give us some insight as to, you know, what employers need to do in terms of reasonable accommodations and things.
Okay, so kind of at the outset, under Chapter 151B, which is the anti-discrimination law, pregnancy can often be perceived as a disability for which they would have recourse if they felt they were being discriminated against. That has existed for some time, but this new Fairness Act goes beyond that and joins 20 other states and the District of Columbia by basically creating, as you mentioned, this accommodation vehicle that prohibits employers expressly from discriminating against pregnant workers or anybody who has pregnancy-related issues in the workplace, whether that be in the hiring, the retention, or in the case of accommodations. So many people often hear of the term accommodations and wonder what that means. So under the federal law, the ADA, it talks about an obligation to make reasonable accommodations if one can perform the essential functions of their job. And so then you do an analysis of whether a person can or cannot do that. So one of the interesting things, though, about this statute is it talks about accommodations, and then it gives a list expressly in the statute of what some of those accommodations might be. And one of the obvious ones might be longer breaks, okay, for either food, water, restroom, or the like, or just a rest break. Other breaks might be changing one's chairs, allowing somebody who needs lactating to have a private room to do some of those things. But one of the interesting dynamics of the law is it goes beyond that and says if a person needs to do light duty, have their job restructured, if they have the ability or need to stop lifting certain weights, have somebody assist them with manual tasks, that those would be reasonable accommodations as well. Now, sometimes people ask the question then, well, if certain tasks are part of one's essential functions of the job and relieving them of those by allowing them to do light duty, are they really achieving the essential functions of the job? And I would say, while they may not be as performing all the essential functions of the job, this law does in fact expect that accommodations would be made.
So employer, again, kind of understanding that in detail and having someone guide them through maybe and putting those accommodations together. spelling
Correct.
them
And
out.
it's considered to be an interactive process, just as under the ADA. And then the question becomes, do I have to, proactively ask if one needs an accommodation? And the law doesn't obligate you to do that. And in fact, if an employer proactively asks somebody if they need an accommodation and the person says no, the employer cannot impose an accommodation on them that the employee does not herself want or need. Similarly, the employer, if the individual says that they need an accommodation, an employer can avoid giving them the accommodation if doing so would create an undue hardship on the employer.
Gotcha. And move to another one that has been in the political realm in terms of discussion, debate at different levels of government. But the mass bathroom bill, as it's been called in some quarters, the transgender bathroom, that takes effect in July of 2018 and has some obligations for employers as well.
So the transgender, the bathroom bill as it was, came into effect last October, a year ago October. But what's interesting about that law is in 2011 we passed legislation that said you can't discriminate against somebody who is transgender. That's one of the protected classifications in employment, education, and housing. But the law did not apply to necessarily restrooms or the use of restrooms and accommodations that needed to be made. So what has happened now in the employment context is if an employer has an employee who is transgender, under the public accommodations law that went into effect last October, it now provides that employers, like all other restaurants and shops and retailers, must now provide transgender individuals the ability to use the bathroom with which he or she, that is assigned to the gender which he or she identifies.
Is there a timeline in terms of when that's going to be instituted, or is that immediate?
So that came into effect effectively last October. Many employers don't have individuals who have presented themselves as transgender, so they haven't addressed this issue yet. But a number of questions have come up on this, and most notably, can I interact with the individual? Does he or she have to officially go through some name change or something else? What if he or she, a male, identifies as a female but has done nothing to change his or her appearance, but now wants to go into the female restroom? And most of the stuff that one reads, they would find that in fact you're supposed to allow them to do so. Knowing that there could be some abuses of this, the Attorney General's office and the MCAD are both crafting and have been working on kind of guides to allow people and penalties for individuals who manipulate things by going in there for inappropriate purposes.
Right. And any sense when that's forthcoming, those guidelines?
So they've been a work in progress, so I don't know when they'll exactly come out. There have been some drafts of stuff, as I understand.
There are timelines oftentimes associated with these things. Legislation is passed, signed into law, but then doesn't go into effect for a certain date to give employers time to prepare. And one of the things that we were just talking about was the Pregnant Workers Fairness Act. So that was signed.
It was the end of July that it was signed, and it goes into effect on April 1st of 18.
And so the idea is that period in between from when it was signed and goes into effect is to give employers the time to kind of get up to speed, update employer handbooks, educate themselves and others.
Yes, in fact, the statute affirmatively obligates employers to not only update their handbooks, but then it also expects that new hire employees would be apprised of this as well, and that employees who are not aware of this, that they made aware of it. So I think a best practice would be to have something posted on the employee bulletin board, as many of these policies are, and to have it in the handbook. And if the handbook is given out on one's first day of employment, that would be the notice to the new employees as well.
Right, make sure they've got that in there. So another piece of legislation that we referred to before we took the break is the Mass Pay Equity Act. And there's federal laws that are currently in place, but the Massachusetts law that was signed this past year, what does that mean?
That's right. So the long and the short of it, people who are conversant in this will often say, but there's a federal law already on this topic, the Lilly-Ledbetter Act, and it is true that that is on it, but that law requires that People of different genders must be paid the same rate for the same work. Operative word is same. The new Massachusetts legislation, which goes into effect July 1st of 2018, provides that people of different genders must receive the same pay for comparable work. And it's that comparable word that replaces the same that is what the big issue on this. It has been and continues to be against the law to discriminate against a female or male gender based upon his or her gender under the anti-discrimination law. That hasn't changed. What has changed now is this new statute gives people an independent right to go to court without having to go necessarily to the MCAD or the EEOC first. So the key issues, of course, are what are comparable, how is comparable work defined?
And that's where you would assist an employer looking at a job description, trying to sort that out.
Yep.
What's the delineation of, some of that's probably gray area, which kind of makes these things difficult.
Well, and that's where I can come in and help these folks. But yes, and one of the things, the takeaways is you don't just look at the job descriptions. The job descriptions are a good guide, but you also look to what the actual duties are.
Right.
It's the duties that
Great
are being
point,
performed.
because you see some job descriptions and there's something in there that they're not doing, or it's
Yeah.
outdated.
Correct, correct. And so that would be kind of what the comparable work would be. So if a person brings a claim because he or she believes that they are not being paid the same wage for comparable work, there is not only the unpaid wage component, the delta between what one person made and what the other person made, but the other thing that comes into play is you can get liquidated damages, effectively a double damage for that, costs and attorney's fees. So people then say to me, well, can we pay people different rates on certain instances if they even do comparable work? And you can. If you're paying somebody more of a different gender because he or she has greater seniority, or if he or she has done extra work, whatever that may be, or he or she works in a different geographic location. Okay, so there are factors that you can, or if one job involves travel, so you could have two people living in two different cities that might be 25 miles away from each other, and the person in the more expensive urban area may be being paid more. That's allowed.
To compensate for that, right. Gotcha, so there are some pieces. And what advice would you have in terms of employers for kind of doing that analysis proactively?
So again, I think that what they should do between now and when that law comes in is effectively to do what I would call kind of a pay practices audit, and to decide what everyone is, find out what everybody's job duties are, what the rates of pay those positions hold, and to determine whether or not there are any disparities in there. Interestingly, in the statute, it does provide that if you undertake that audit and determine that there are pay inequities, and you start taking affirmative steps to correct those, even if you haven't corrected them all by July 1st of 2018, that's an affirmative defense that will help you stave off the double damages and these other things, because the legislature affirmatively wanted employers to take these proactive steps. Another aspect of the law that people often don't know about is there's something we call the pay secrecy provision. Many employers don't want employees to talk among themselves about what they're earning. This law expressly provides the ability for employees to now talk among themselves about what they earn, and even allows employees to ask HR what other employees earn. HR, however, upon receiving such a request, is not obligated at all to say what somebody else makes. The other aspect of the pay secrecy point is many employers will say before they're making an offer to somebody, what do you earn at your present job? This law now prohibits that question from being asked, and the only thing an employer can do, or a prospective employer can do, is to analyze whether or not there's something publicly available that would determine what the salary is, or if the person says that they won't accept the salary offered because that's less than they earn presently, they've now opened the door for the employer to say, well, we might be able to pay you more, please tell us what you earn presently. If the person opens the door to that, you can do that.
So, you mentioned HR department. Majority of the businesses that are members of the Chamber of Commerce are 5 employees or less. And the vast majority of small businesses that drive the economy of the country are small businesses. You don't have an HR department. How do you encourage or advise a small employer to that may not have an HR department? What would you say between now and then?
Well, so So first of all, I would invite anybody to call me with any of these questions, obviously. I serve in that role for a lot of folks where I kind of give them what
Right.
I hope to be the sage advice. I also encourage people to attend seminars and read articles on those topics.
And you have a couple seminars coming up that I want to make sure we get out in the next couple minutes that we have left.
Yeah, no, I do. And in fact, on October 5th and October 17th, on those mornings, I'm conducting a series of two employment law seminars. The first one is at the Verve Crown Plaza on Route 9 in Natick on the morning of the 5th, and the other one is at Cyprian Keys in the Worcester area on the 17th. But for any employers who don't have HR departments, I suggest that they really kind of try to do their best to keep up with these laws. Many employers don't know about what should be in one's personnel record, the documents that need to be in there, the records retention schedules, and then they'll get these letters from, let's say, the AG's office or the Department of Labor or OSHA or one of these agencies, and their heads spin because they don't necessarily know where to turn. So attorneys like myself who are really specialized in labor and employment law, I think are excellent guides to do that. The other benefit of an attorney versus just a third-party HR would be that you've got attorney-client privilege.